on how you can respond to the employment law changes hitting us in April. And a special hello to anyone who is joining us for the first time. My name is Sarah Gray, and I'll be taking you through quite a bit of information today. Actually, that's a bit of an understatement. There's a lot of information, but don't worry, you'll receive a link to the recording together with a copy of the slides after the webinar, so you won't miss anything. Let's get going. Sorry, bear with me. I'm just having a few little technical problems. As always, sorry, I meant to mention, if you have any questions, please drop them in the chat and we'll make sure that they're answered either during the session, or if we have time, we'll send out a Q&A sheet with the slide deck as well, so you'll have that. This is all about the Employment Rights Act 2025, and there is no doubt this is significant. And just what we want to do today is to ensure that you're as prepared as you possibly can be, not just for April, but more importantly, for what else is coming down the line, as some of these changes will affect the people you're employing from July this year. Today, we're going to focus on what you need to have in place for the changes to employment law legislation, as I said, coming in April. These changes are significant, and the impact of not being compliant is going to be very expensive. So over the next 50, 60 minutes or so, we'll focus on the practical steps that you need to start taking, and what you need to be thinking about now, finishing with what's on the horizon for 2027. So buckle up and we'll get started. Before we focus on April though, let's just review what has changed already this year. These are the changes that came through in February 2026, the 18th to be exact. And all of these were about trade unions. Now, I'm not going to go through each of these now, but you will have this in the slide deck to refer to if you need to. Just be aware that they do exist, and if you have a unionised site, make sure that you're familiar with these changes. Basically, things have got easier for the unions. That's pretty much the bottom line. Now let's head into April. Change number 1, statutory sick pay. 3 changes come into force on the 6th of April, and 2 of these are particularly significant. First, workers now get statutory sick pay, SSP, earlier. The 3-day waiting period has been removed, so SSP is payable from day 1 of the absence rather than the 4th day as it is currently. Second, very low paid workers now qualify for statutory sick pay for the first time. The lower earnings limit, which previously blocked anyone who was earning less than £125 a week from getting SSP, has been removed. This benefits 0 hours and part-time workers who are doing just a few hours each week, and means they're also eligible now for sick pay. The statutory sick pay rate will also rise slightly on the 6th of April from £118.75 to £123.25 per week. And there's a new formula to make sure that no one receives more in statutory sick pay than they earn. Employers get whichever is lower. So that is either the standard weekly rate or 80% of their average weekly earnings. And those average weekly earnings are determined from the previous 8-week period. These changes expand both coverage and cost. If you haven't already acted on these changes, here's what you need to do. 1, update your absence policy and template employment contracts. So remove any references to the lower earnings limit and to statutory sick pay only being payable from day 4. Those provisions no longer apply. Now, when I talk about policies throughout the session, Anyone who is a client of Cintra HR Outsourcing automatically has access to the new updated policies. If you're not currently a client, email us and we can let you know how we can assist you with the provision of policies if you need them. Number 2, brief managers and staff. So make sure everyone knows the rules have changed, and it's probably a good idea to flag the potential financial impact that may impact on the business to your senior leadership team. Check your payroll system. Your HRIS and the payroll processes that you have need to be set up for day one statutory sick payments and the new low owner rate. So of course, if you use Cintra for your payroll, this will happen automatically in our systems as they've been changed to accommodate this. The next is to review your absence management procedures. So this is a good moment to think about what more you can do to reduce the risk and cost of absences, genuine or otherwise. Do managers hold a return to work meeting after every absence, however short? It's a question. Are they picking up on suspicious patterns, like a team member who regularly calls in sick on Mondays or takes every second Tuesday off? Those sorts of things. I think it's likely that you will see some rise in short-term absence, at least initially. When you remove a cost or barrier, it's quite normal to see an increase in utilisation. However, it's not necessarily abuse. Often it's about people using a right that they previously could not afford to. So this is likely to have an effect on 1 to 2 day absences. And it could also result in a shift from what we call presenteeism to absenteeism. And what do I mean by that? A government report from last year stated that 58% of workers reported working whilst they were unwell. This figure is likely to be high because A, people are not able to financially cope with being absent and not getting any pay, or it might be that they're trying to avoid hitting absence triggers. With this change to legislation, it's more likely that they may take the day off as sick if they're unwell, and it will now be recorded as absence. But, let's not be too pessimistic about this, because there is a chance that over time, this will reduce overall sick days. How? Well, when you reduce presenteeism, that is when people are coming to work because they have to, even though they might be sick, you may get less of a spread of illness and therefore have less people off work. Also, if an employee takes 1 to 2 days off early in the piece, they may avoid a worsening illness or longer term absence. The next thing to do is to review the impact on any company sick pay scheme that you have. So if you pay company sick pay, check whether this change affects you. If your scheme only kicks in after a 3-day waiting period, you now have to provide statutory sick pay on those days. You can probably tweak your company sick pay scheme to claw back on these costs, but you may need to consult staff first. Of course, if you pay company sick pay from day one, you'll not need to worry. We've heard some employers express concern about more employees taking time off as sick days. So what I would suggest you do is to have a session with your teams and go through the changes to the sickness absence policy to advise them of the statutory sick pay provisions from day one, and make it clear that your absence reporting procedure still applies. And hopefully you have that written down. But more importantly, the question needs to be asked of line managers about whether they follow it. We often find that's an issue. You also need to ensure that they know that managers will monitor absences closely, that excessive sickness absence will trigger absence management procedures and could ultimately result in dismissal. And anyone found taking a non-genuine absence would be deemed to be a disciplinary offence. And let's not forget, the amount of money that they get on statutory sick pay is hardly likely to be an incentive or a replacement for their wages. I think we're talking about less than £25 a day for a full-time employee. So it's not a lot. So a quick poll. Could you please tell me, question number 1, with statutory sick pay becoming payable from day 1, what impact do you expect on short-term absence in your organisation? Would it increase significantly, increase slightly, no real change, or do you expect it to decrease? If you can just pop your answers in there. Okay. The second one is around what's your biggest concern about the move to day 1 statutory sick pay? An increase in short-term absence, abuse or more duvet days, cost impact, or managers' incapability, or capability, I should say, to manage absence, or no major concerns? So it looks like no major concerns is a top answer. That's fantastic. Thank you for that. Now, we're going to head into change number 2, which is day 1 paternity and parental leave. There are 3 changes to family leave that come into effect on the 6th of April. First, paternity leave becomes a day 1 right. So previously, employees needed 26 weeks of service to qualify. Second, unpaid parental leave also becomes a day 1 right from day 1 of employment. So this used to be subject to a 1-year service requirement. Newly eligible employees became entitled to give notice of their intention to take paternity or parental leave on the 18th of February. So this may have already started flowing through. There's one more change worth mentioning here. It isn't an Employment Rights Act provision, but it takes effect on the same date. So from the 6th of April, bereaved fathers and partners will be entitled to up to 52 weeks of bereaved partners' paternity leave if the mother or primary adopter dies within the first year of a child's life. We've developed a brand new policy on this, so please ensure that you download it and include it in your suite of policies, your family-friendly policies. It covers who is entitled to it, how much leave can be taken, the notice requirements, and the employment provisions that exist. Sorry, I'm having trouble manoeuvring my mouse around. Actions for you to take. Update your policies, or if you have access to ours, replace the ones that you're using with the new ones. Make sure your line managers are aware of these changes and that they know where to find the policies so that they can provide the right information to employees when they ask. Change number 3, collective redundancy consultation. Now let's have a look at the provisions for this. If you're ever in a position where you need to make large-scale redundancies, and hopefully this is not the case, this change matters. The penalty for getting collective consultation wrong just doubled. So the law says that if you're thinking about making 20 or more employees redundant in a rolling 90-day period, you have to consult with a recognised union, or if you don't recognise a union, with the elected employee representatives. And the purpose of the consultation is to minimise the impact of the redundancies, and the consultation has to last at least 30 days. Before the 6th of April, if you breach these rules, a tribunal could order you to pay an award of up to 90 days' pay to each affected employee. That has now risen to 180 days' pay for each affected employee. The actions that you need to take ensure that consultations are not delayed and start obviously in good time. Can't stress this enough, document all your decisions carefully. Any decision making that you do, note it down, the reasons for it. And remember, the stakes are higher than ever. If you're proposing to make 20 or more employees redundant within a 90-day period, follow the collective consultation rules scrupulously. A mistake that might once have cost you 90 days pay per head will now cost you double. Change number 4 is sexual harassment whistleblowing. So as of the 6th of April 2026, workers who disclose sexual harassment are now entitled to whistleblowing protection. To qualify for that, they must reasonably believe that the disclosure is in the public interest. So, what is public interest? First up, it doesn't mean that it's something that affects the whole general public. It means something that goes beyond a purely personal grievance and has a wider impact on others. ACAS guidance and case law steers us towards this definition. More than one person affected or potentially affected, a wider workplace or cultural issue, or ongoing or systemic behaviour. So let's have a little poll on this, if you don't mind. A complaint has come in that states that a manager is making inappropriate sexual comments to multiple team members. In your opinion, is this A, an issue likely to be in the public interest, or B, an issue unlikely to be in the public interest? Looks like most of you have got that right. It's A. And the reason is because it affects multiple individuals and it suggests a cultural or systemic issue, and it's an ongoing risk. So here's another one. Question 2. What about the scenario that someone has complained that sexualized jokes and behavior are common across the department they work in, but no one complains as they are ignored? Is this A, an issue likely to be in the public interest, or B, an issue unlikely to be in the public interest? What do you think? Most of you look like you've got that right. It's A. And that's because it's a cultural issue, it affects a group, and also it's a breach of employer duty, especially under the Worker Protection Act. Now, one last one. What if someone says, I don't like how a manager speaks to me, kind of feels inappropriate? Is that an issue likely to be in the public interest or an issue unlikely to be in the public interest? Great. The answer is B, and most of you have got that right. Then that's because it's subjective. It's an individual issue and there's no evidence of broader risk. So thank you for participating in those polls. That's great. Now let's head on to what actions. This change largely confirms what the courts and tribunals have already been saying, but it may lead to greater awareness of sexual harassment whistleblowing as a claim, and it might see an increase in complaints. So think about refreshing managers' training so they can spot a potential whistleblowing complaint and respond appropriately. And make sure your whistleblowing policy includes sexual harassment as one of the concerns that you encourage staff to report. It's also worth revisiting whether you can clearly demonstrate that you've taken sufficient reasonable steps to prevent sexual harassment in the first place. If you've not done a sexual risk audit yet, you should. Without it, even if you do training and have a policy, you are unlikely to satisfy the requirements sufficiently, and a successful claim could end up in an automatic uplift in the compensation award. Change number 5 is about the Fair Work Agency. And this again is happening in April. It's kind of gone under many people's radar, but it could be significant. This is all about the establishment of the Fair Work Agency, which is a new enforcement body for certain employment rights. In some respects, it's an administrative reorganisation. So various existing functions have been brought together in one place. So for example, enforcement of the national minimum wage will move from the HMRC to this new agency. But the agency, apart from that, also has some new powers. The most important is the ability to fine employers who underpay holiday or statutory sick pay. The regime mirrors minimum wage enforcement, so the Fair Work Agency can require you to pay an amount you owe to an individual within 28 days. It can also impose a penalty of 200% of the sum that you owe that individual, capped at £20,000 per worker. That's still a lot. This will be reduced to 100% if you pay within 14 days. So clearly they want to get people paid correctly, quickly. You will also be under a new duty to keep records showing that you've complied with the holiday entitlement and pay rules. The key points are that records must be kept for 6 years, even after the employee has left. We usually say 6 years plus 1. The Fair Work Agency has the power to inspect those records, and failing to keep adequate records is a criminal offence which will be punishable by or fine. The statutory sick pay position is a bit simpler. There's no equivalent record keeping duty, and statutory sick pay disputes are unlikely to involve large sums, but holiday pay is a very different matter. Like the national minimum wage, holiday entitlement can be complex and it's easy to make mistakes. Actions that you can take. What should you be doing now? You must get your holiday record keeping in order. There's no prescribed format, but you do need to be able to show how much statutory holiday each person has taken, that you correctly calculated their holiday pay, and that you actually paid them what they were owed. Mistakes can arise if leave needs carrying over. There are changes like someone moving on to sick leave during a booked holiday or their manager withdrawing approval. Can also happen when you take on a new hire partway through the holiday year or need to make a payment in lieu of unused holiday on termination. Mistakes happen if employees work part-time or work irregular hours or for part of the year. And this is the one that we often see errors in. Employees who regularly receive overtime or commission payments, bonuses or allowance, that must be factored in to their holiday pay. And that's quite often something that that gets ignored. So it's important that your record keeping system accurately captures who's entitled to what and what they've received. A central HRIS is ideal and makes it straightforward to produce records quickly if the Fair Work Agency comes calling. Whatever system you use, train your managers to use it correctly and consistently. And if you don't have one, ask us to arrange a demo of our Sintra People HR system. But let's be realistic here. Unless you're a very large business, it's doubtful the agency is randomly going to come knocking on your door. But if employees think you've got your sums wrong, they might contact the Fair Work Agency and then it obviously will investigate. Also, employees can bring unlawful deduction from wage claims in the usual way, and so, good record keeping can protect you from such complaints too. With regard to statutory sick pay, there's no equivalent record keeping duty, and as I said, disputes are unlikely to involve large sums. Holiday pay, of course, is a different matter, and holiday pay, as I said, can be quite complex and it's easy to make mistakes. One more thing to watch out for. Make sure you haven't misclassified anyone as self-employed when they're really entitled to holiday pay. So if you're using independent contractors, check whether they actually check that the work that they do hasn't drifted towards something more suggestive of a worker or employee status. And if it has, consider payment for holidays. Right, so you'll be pleased to know that that's April done and dusted. So we're turning our attention now to what's happening in October. The government had originally planned to introduce its ban on fire and rehire in October, by the way, but that's now been pushed back to 2027. So there's a bit of breathing space on that one. But you do need to focus on this October because there's new rules on harassment at work, and there are two very important and connected changes coming, and these are them. The first is the reintroduction of protection from third-party harassment. Now, this is a really big deal if you're in a public-facing business like hospitality or retail, but it's going to affect all employers to some extent. The second is that you need to take all reasonable steps to prevent sexual harassment, not just reasonable steps, all reasonable steps. And the only way you're going to be able to ascertain what kind of risks you may be looking at is to do a full evaluation of the circumstances around your business. And this is where an audit comes in. Otherwise, how can you demonstrate that you've done this effectively? Regarding third-party harassment, put simply, if a customer, a client, a contractor, supplier, or any kind of visitor harasses a member of your staff, sexually or otherwise, you can be held liable for that harassment, even though you don't employ the person behaving badly. The good news is that if you will have a defence if you can show that you took all reasonable steps to prevent the incident. So you can't stop any incidents occurring, but you can show that you've taken all reasonable steps to make sure that it doesn't happen. Now, let's take a look at some of the actions that you can take. If you're a customer-facing business, you've probably already taken some steps here as a matter of good practice. But to make sure that you're covered, there are 6 actions that we recommend. 1, assess the risks to staff and put safety measures in place. That might mean alarms or code words for employees who visit clients alone, avoiding lone working in high-risk situations. You could install CCTV in some public areas or even body cams in certain roles. 2, you set clear expectations with third parties. And this is really important. You'll see if you go to a doctor's surgeries or a hospital, there's always signs up. So signs, handouts, or recorded phone messages as well can communicate that harassing your staff is unacceptable and may result in you banning the perpetrator from your business or withdrawing your services. Address the issue in your contractor relationship. So tell contractors what steps you expect them to take to prevent their staff from harassing your employees. Make the consequences of any breaches clear, whether that's removing an individual from your site or terminating their contract. Ensure that you include this in your contractor agreements. That's something that you can fairly easily do. Update your anti-harassment policy and training. Sorry, I just see that my slides got a little bit out of whack there. Both should cover third-party harassment and encourage employees to report incidents. So make sure that your policy does that. Whether they're a witness or whether they are in fact the target. You should also explain how you will respond to those complaints. Training customer-facing staff in de-escalation techniques can also be really helpful. Next, Take allegations seriously. Investigate all complaints and take action against the perpetrator where necessary. If they work for a client, contractor or supplier, report this and then ask your supplier or contractor to intervene. Then make sure you document and implement the lessons learned from that situation. And next, importantly, support affected employees. I mean, that might mean providing counselling or putting in place a phased return to work, or in some cases, helping the employee to file a police report. And this is an important thing to remember, not to penalise the victim. So, for example, if you determine that you want to solve the issue by reassigning somebody who's being harassed so that they don't encounter the harasser again, make sure that that actually isn't a demotion for the victim. So be very careful about what you do. And then, of course, taking all reasonable steps. The 2nd October change has had a lot of discussion around it, but will probably have little additional impact as long as you are compliant with your current obligations. In October 2024, the Conservative government introduced an extra requirement known as the Sexual Harassment Preventative Duty, if you remember. This provided that if you don't take reasonable steps to prevent sexual harassment, that a tribunal could increase the claimant's compensation by up to 25%. The Employment Rights Act 2025 is tightening this, making it so now that you will have to take all reasonable steps to prevent sexual harassment to avoid that 25% uplift. So how can you prepare for this change? Regulations specifying what counts as all reasonable steps for preventing sexual harassment are expected to come out in 2027. So we'll have to wait and see what these are. However, we're not expecting the legislation to contain special new steps that no one's ever thought of before. So for now, check that you're taking all the familiar steps set out in case law and existing Equality and Human Rights Commission guidance. And that way, even if something does go wrong, you will have a strong defence. The steps to focus are to assess the risk of harassment in your work and your particular business. And as I mentioned previously, we can do this for you. We've got an excellent sexual harassment risk assessment audit process that identifies if you've got any clear risks. We also run an anonymous survey with all employees to get their input. And believe me, this can often throw out issues that you are blissfully unaware of, but do need addressing. And then we then provide you with a report with key actions that you can implement. And it's an excellent source of evidence should you ever need to defend a claim. Make sure you have an anti-harassment policy that's effective, well communicated, and easy to find. And if you're one of our HRO clients, you'll have access to this. Train your workforce and managers with regular refreshers, and make this a topic of normal conversation so that issues get out in the open early. Senior leadership should take the charge on this and obviously provide a good example. And lastly, monitor and review. So revisit your policy annually, repeat your risk assessment and audits if there's any significant business change, and make sure that you learn from incidents as they occur. A few other things in October, the changes worth flagging. There's further trade union reform that will affect you even if you don't currently recognise a union. So from October this year, you'll be required to inform new employees of their right to join a trade union. So that will be something to include in your onboarding process. You'll also have to remind existing staff of this right periodically and regularly. Trade unions will gain the right to access your workplace for activities like recruiting and representing members. So you might need to get used to dealing with trade union representatives entering your workplace for the first time. The government is also making it easier for unions to secure recognition. So just be aware these changes are in the pipeline. If you already consult your workforce and address concerns effectively, that helps reduce the risk of them feeling like they need to unionise. And if you're in the hospitality sector, which I know a number of our clients are, be aware that there's a further tightening of tipping laws also planned for October. We'll let you know what those are as and when they come into play. And finally, for October, although it's listed as no earlier than October 2026, which could suggest that it might slip, this is the proposed doubling of the time limit for bringing an employment tribunal claim from 3 months after the act that's being complained about to 6 months. So what do you need to do? There are 3 things here. Review your retention periods for HR records. So don't delete anything important until at least 9 months after someone has left, because ACAS will normally try to facilitate a settlement, and that can extend the time limits for yet another 3 months. If someone brings a claim, you may need that material as evidence. Use the extra time wisely, so employees will have longer before they have to issue a claim, which gives you also more opportunity to resolve the dispute. So, as I say, use the time wisely. And remember, use ACAS. Their conciliation service will try to get you and the employee to settle your differences instead of the claim going to tribunal. Of course, the flip side is that you may not know for 9 months whether a dispute will result in a claim. So key witnesses may have left the business by then. So the idea is to get statements from any key witnesses promptly and keep them securely, and try to maintain contact with former employees that you might need as witnesses. So that covers October. Next, you need to prepare for January 2027. And this is when the 3 biggest changes hit us. And there are some steps that you need to take urgently now, even though it's January 2027, to reduce the impact. So let's go through those. The first change is that the qualifying period for unfair dismissal protection is dropping from 2 years to just 6 months. So anyone working for you can raise a claim for unfair dismissal with just 6 months of service. The government has abandoned its earlier proposal for day 1 unfair dismissal rights and a mandatory probation process, so that's good news. But the current plan is still a dramatic change, and it has an immediate impact on your business. And here's why. Every employee with at least 6 months service on the 1st of January 2027 gains unfair dismissal protection on that date. So that means that you'll only have 6 months to assess the performance of anyone that you hire from the 1st of July this year before they get unfair dismissal rights. This change may also affect how you manage existing employees. So let's say you hired someone on the 1st of April this year with a 6-month probation period. That ends on the 30th of September. Now, say their manager isn't sure that they're quite up to standard, and they want to extend the probation by 3 months, which takes them to the end of December. The manager then decides they want to dismiss, but your business closes over Christmas and New Year, and they don't get around to speaking to the employee. So by 1 January, that employee now has 9 months service, and that means that they have unfair dismissal protection. So to dismiss them for poor performance at that point, you'll need to follow your full-blown formal procedure. So it's important to, as I say, get it together now. That little example I just gave you shows that you need to start taking the steps right now to get ready for the shorter unfair dismissal qualifying period. And here are 5 things that you can do. One is review the length of your probation period. If it's currently 6 months, I would suggest cutting it down. 3 months is good because it gives you scope to extend the probation. It also gives you a little wriggle room. So if a manager passes someone's probation only to have second thoughts, which, is quite typical, or is a bit late holding the final probation review. Second, review your process for assessing new hires. You really need to implement a reliable system to evaluate suitability quickly. I can't stress this enough. Ensure managers know how to set measurable targets, how to communicate their expectations clearly, and what they need to do to provide support, training, and regular feedback, and how to encourage employees as well. They need to stick to the timetable for probation reviews, and they also need to understand what constitutes a pass or failure for that employee. The third one is to tackle underperformance now. So if you have any employees with less than 2 years service who will have at least 6 months by 1 January, do you? If their performance isn't up to scratch, address it this year. After January, as I said, you'll need to go through the full formal process before dismissing. The next one is to look at your recruitment process. Really tighten it up. Don't just accept question and answer interviews. Use assessments, use skill tests, use scenario-based interviews, and also just don't accept reference checks. I mean, as I said before, the best ones are often from people who have had settlement agreements, because it's part of the settlement agreement, they get a good reference. In our business, we use HMRC reports as one way to verify employment dates and where they've worked, and of course they can't fudge that. So, you might want to think about that as well. And the next one is to update your HR documents. So if you reduce your standard probation period, you might need to revise your template contracts, your offer letters, manager guidance, etc., to reflect this. Another major change to unfair dismissal law is also due to take effect on 1 January next year. And this is the removal of the cap on unfair dismissal compensation. So currently, compensation is limited to 52 weeks gross pay or £118,000, whichever is lower. The government is abolishing both of these caps. In practice, most awards for unfair dismissal are well below those thresholds. At the moment, the median unfair dismissal award is around £6,750. And that's because compensation reflects the person's actual financial loss. And most employees find a new job quickly and aren't high earners. So in most cases, removing the cap won't make a huge difference. But, and this is a big but, for high earners, this changes the picture significantly. So people who wouldn't have otherwise bothered claiming due to the cap being low may start doing so. And there could be some eye-watering awards. And if you're negotiating an exit package with a senior employee, it means they're going to probably push for more once the cap is gone. They've got more negotiating power. Even lower paid employees might overestimate what a tribunal could or would award them and be less willing to settle. There is a possible upside though. Employees with too little service to claim unfair dismissal or with earnings above the cap sometimes use discrimination or whistleblowing claims instead. So we might see simpler unfair dismissal cases replacing some of the more complex ones and contrived claims that we've seen in recent times. So what can you do to prepare? If you have a senior staff member whose performance is a little bit lackluster, now is the time to remove them from the business. Come January, you'll have to follow your full performance management process or dig deeper into your pockets to persuade them to go quickly and quietly. The other big reform scheduled for January 2027 is the ban on fire and rehire. This will make it automatically unfair to dismiss an employee for refusing to accept changes to core contractual terms. You won't be able to force through such changes using fire and rehire. That's dismissing the employee and offering re-engagement on worse terms. And fire and replace will also be outlawed, which is dismissing the employee and replacing them with someone prepared to accept the worse contract. This ban on contract changes covers things like pay, hours, pension entitlements, shift times, length of shifts, and time off. There is a narrow exception, though, which permits these changes where your business is teetering on the brink of insolvency. For more minor contractual changes like a move to new premises, dismissal won't be automatically unfair. Instead, a tribunal will weigh up whether the change was reasonable, looking at things like your reasons, how much you consulted, and what you offered in return. The government is still thrashing out some details, but we should have more clarity on what contract changes are banned or not in the coming months. So watch this space. With this reform looming, it's sensible to consult staff this year on any major contract changes that you may be considering. It's still a tricky process and you must follow the code of practice on dismissal and re-engagement, but the new rules are only going to make it harder to reach agreement. So maybe it's better to bite the bullet now. If you offer, and this is something you might want to consider, if you offer an annual discretionary pay rise, it may be a good time to propose contract variations, and you can link the increase to employees accepting the changes that you're proposing. How are we going for time? It's always the way. That's the January 2027 picture. So let's quickly look at what's being proposed further down the track. Key details are still missing, so for now, just be aware that changes in the pipeline. A few reforms worth flagging that are due later in 2027 are enhanced dismissal protections for pregnant women and new mothers, a day one right to bereavement leave, including for employees who experience pregnancy loss, changes to the threshold for collective redundancy consultation for multi-site employers, and also a requirement to give written reasons when refusing a flexible working request. There's also one final set of changes that could have a fairly huge impact on your day-to-day management processes if you employ any casual or shift workers. Under these changes, you'll have to offer guaranteed hours to zero or low-hour workers, give shift workers reasonable notice of shifts or shift changes, pay shift workers for any shifts that you cancel, curtail, or move at short notice. So the guaranteed hours plan is complex and there's a long list of unknowns about how it might work. These changes won't happen until 2027, but it might be worth starting to map out your position now. So ask yourself, who do you typically recruit as casual workers? I mean, students, for example, are unlikely to want to accept guaranteed hours because they need the flexibility to manage their studies. So that could make them an ideal candidate for the future. Ask yourself what hours and patterns your casual workers are actually working. That could help you assess the impact of moving them to fixed hours. How often are managers giving very short notice of shifts or shift changes? Are they giving them, are they saying less than a week? And is that avoidable? Can you put new processes in place? That said, don't get too preoccupied with this one yet. We'll know significantly more in the coming months, and the reforms may get scaled back, so I don't want to frighten you unnecessarily on that one. And we're on the home stretch now, folks. So we've made it through the Employment Rights Act 2025. It really is a mammoth piece of legislation that will keep us all on our toes for the next couple of years. We've covered a lot of ground, so let's finish by pulling together the key things to take away from today. First, if you haven't already updated your policies and payroll for this April's changes, do that now. So that means statutory sick pay from day one and day one paternity and parental leave. And again, we can help you with that. Second, start preparing for the October harassment reforms. Review your risk assessments, refresh your training, and make sure your anti-harassment policy covers third parties. Again, that's something that we can help you with. Third, get your house in order on probation and performance management. The unfair dismissal qualifying period drops to 6 months in January. And this, as I said, is probably the most urgent thing on the list, in my opinion, apart from statutory sick pay, which is coming in a few days' time. And fourth, keep an eye on fire and rehire and the guaranteed hours rules. The detail is still emerging, and obviously we'll know more in the coming months. So I think I just skipped a slide there. Apologies. This is, look, this is, as I said, a very fast-moving area, and there's a lot to obviously take in on board. There's a lot of changes that you need to make, and I'm sure that some of you have got some questions. I don't know if I can see the questions, actually. Let me see if I can see any that are in there. Somebody's asked if we can go back. Oh, I didn't see that. Can we go back one slide? But you'll get the slides, everybody, so don't worry. And the rest, I think what we will do is I'll put those, I'm having trouble reading them off here. What I'll do is I'll collate the questions that we've received as part of the chat. We'll put those in a document and we'll send those out to you with the answers, so that you'll all get all the questions and all the answers, as well as the slide deck and a link to the recording. And really, that's me. I'm Sarah Gray, Head of People and HR Outsourcing, and I really look forward to talking to you next time. I hope you've got some good information from today. Good luck in all the implementation, and so goodbye until next time. Thank you very much, everybody.